Good afternoon, everyone. I have the pleasure of introducing the next panel. To my left, we have Meaghan McMahon. She is a former member of the executive of our organization, a partner at Davies McMahon in Ottawa. I understand that she's acted on behalf of interveners at the Ontario Court of Appeal and the Supreme Court of Canada, certainly a rising star in our bar. Beside her, we have Daniel Brown. He is the past president of our association, and I expect everybody should know that he's written the book with Justice Jill Witkin on prosecuting and defending sexual offenses. Just a shameless plug for Emonde. They are here today, and I just learned there's a third edition of this book, so I would urge everyone to get a copy. We also have Dominic Lamb, who has joined us. He is a co-founder of Lamb & O'Brien, a certified specialist in criminal law, and the past president of the DCAO. A special thank you to both him and Meaghan because they flew here from Ottawa, and a warm welcome to our panelists. Thank you.
Okay, so we have a lot to cover in 30 minutes. We've decided to pick 4 high-level topics. We're going to see how much we can get through. So this is going to be, as we've kind of called in our prep, a bit of a drive-by. So our slides have a lot of info. We're probably just going to kind of touch on things and highlight some cases that we want to bring to your attention. Oh, no. If you can change the slide for me, please. Thank you. So just picking up where the last panel left off, before I jump into myths, stereotypes, and common sense assumptions, the case on this is from earlier this year from the Supreme Court of Canada. It's called Kruk. And common sense assumptions that the last panel talked about, the rule against ungrounded common sense assumptions, there's no longer, in terms of raising this as a ground of appeal, it's no longer recognized to be giving rise to an error of law. It's reviewable only for palpable and overriding error. So if you have a case where you think this is going to come up, you have to read Kruk. It's complicated, but it deals with all of these issues. So I just wanted to raise that because the last panel was touching on it. So if we can go to the next slide, please. So the basic rule that we all know, this isn't new, is that it's an error, this is an error of law to rely on a myth or a stereotype to undermine the complainant's credibility. And Kruk includes some of the most common myths and stereotypes that come up. If we can change the slide, please. But we also know that Crowns have a tendency to argue for an overbroad application of this general rule. And if they're doing that, that can lead to the inappropriate rejection of defense evidence. So don't let them get away with it. If you can lay an evidentiary foundation demonstrating a relevant purpose to your question, then you're not invoking a myth or a stereotype. And the trier of fact is required to give your question, your suggestion, fair consideration. So you can cite Kruk for this general principle, and then if we can change the slide, I've provided 4 areas of common examples, I think, that tend to come up. And these are all areas that touch on a recognized myth or stereotype, but it doesn't mean you can't ask questions in this area. So we've provided some cases to give you confidence in being able to point to a specific relevant purpose for why you're asking a question that may seemingly touch on a myth or stereotype, but you're asking the question for a non-myth or stereotype purpose. So JC, another Justice Petracco case, the complainant, the suggestion was that she had a motive to fabricate a sexual assault allegation to hide her infidelity with the accused from her boyfriend. And Justice Petracco said that's absolutely relevant to her credibility. Delayed disclosure. This was a case where SG, the complainant, made an assault allegation. It's set for trial. Trial doesn't get reached on the day of trial. After the trial date passes, the complainant goes to the police and discloses an additional assault and a sexual assault, both of which predate the original assault. And she said that the reason for her delayed disclosure was because she wasn't comfortable talking about sexual matters in public. Well, that's fine in terms of why you didn't disclose the sexual assault, but that does not provide an explanation for why you didn't disclose the other assault. So again, that was held to be absolutely relevant to her credibility. Post-offense contact between accused and complainant. I've provided a case that goes through a good analysis of the competing considerations at play, though it's not an example of success, I will warn you. But it does illustrate that in that case, it wasn't successful, but you can ask a complainant about post-offense contact with an accused, including a consensual sexual relationship with the accused after the alleged assault has taken place. It's then up to you to make the submission that the complainant's explanation for the continued contact, the continued consensual sexual relationship, is not reasonable and that it lacks credibility if that's your position. The last one I wanted to highlight was inconsistent statements. That's going to be very fact-specific to your case. I've provided some examples there, so in the interest of time, I won't go through them. And if we can change the slide. The last thing I wanted to comment on with respect to Kruk is the Supreme Court reiterates the importance of WD for your client's testimony. So the takeaway here, I think, is that when you have a case where the Crown is pulling out JJRD saying the accused did well, but the complainant did really well, so you have to convict, we can rely on Kruk in response that says you don't throw out WD. JJRD does not displace the WD analysis. All it's doing is reiterating really basic principles that we know from other cases. It's putting them in one nice, succinct paragraph. So I simply highlight this as something you might find useful when your client testifies in these trials.
So where do we go from here? And I apologize, our panel is a bit more vanilla than the last one that came. Can we just go ahead 2 slides, please? There we go, one more. So I'm going to talk a little bit about motions for direction, and that's in the context of whether you're bringing a 276 application into other sexual history, or talking about whether you have private records in your possession. The question is, sometimes you have something you're not sure whether this falls into either category, and you have to go through the whole process of a 2-stage application where you reveal not just what you have, but why you're planning on using it, or can you perhaps just pre-screen it? The other option is just not to screen it at all, and there's some risks with that we'll talk about. And then later on, Meaghan will pick up a little bit about 278 applications, and then Dominic will talk about some more 276. But we're just talking right now about these threshold issues. So why are you bringing a motion for directions? It's number one, we might be talking about whether or not we're dealing with other sexual activity. We heard that there's been some recent case law that sort of is talking about, is this the event itself, or is this something that happened 15 minutes earlier in the cab ride, and is that part of the same transaction or not? Reimer speaks about this, but you may not know where your event sort of falls on that spectrum, and you might want to have a judge rule on that. Another example might be whether or not the activity itself is sexual activity. What I mean by that is, for example, if the complainant had said, you don't need to use a condom because I'm on birth control, is that fact that she's on birth control revealing something about other sexual activity or not? And you might ask a judge just to have a quick screen of that to make sure you can adduce that evidence without having to bring an application. You may have something in your possession, a text message or a collection of text messages that you think are really mundane and couldn't possibly meet the definition that's set out in JJ for private records. Can you just show that to the judge and ask them to rule on it? Or the last piece is, in the context of the sexual event that's under or before the courts, whether or not something depicted in your record is of explicit sexual activity. It might be a video of or part of the encounter that's captured on video, and is this something you can use without an application? So where do we get the authority for a motion for directions? It's a residual common law power. It's not legislated anywhere, but JJ says it exists, and it's within the trial judge's discretion to engage in it. And trial judges really should engage in it because it makes trials more efficient. That's your argument. And you may also want to remind the judge that the time it takes to deliberate in the trial itself and decide these motions is all part of that 18-month delay ceiling. There's a recent case from the Court of Appeal called Mengistu that reminds judges of this. So judges are going to want to find ways to be efficient, and this is one of those ways. There are also a few cases that really sort of encourage the use of them, and also separately, these things can be done in writing, so they don't have to have a court date consumed in order to decide these issues. They can be decided just in a written application to the judge. When are you not supposed to use a motion for directions? Where the issue is debatable, where the Crown can make as good an argument against you on it, I think that's really the time when you should just go straight to a stage 1 application. Motions for direction are really supposed to be those most obvious cases that couldn't possibly engage the interests of 276 or the 278 records regime. And if you're not sure, JJ says you should screen. And if you are sure, go through this application. Even in Reimer, there was a comment made by the Justice Pachaco where he said, in this particular case, this should never have been decided as a motion for directions. This is the type of thing that ought to have been screened in a 2-stage process. I've already heard Crown saying that this is the authority that we should never have a motion for directions. It was in the context of that case that those comments were made, but just be aware that if you're litigating something that's going to be hotly contested, chances are you should have just gone to a stage 1 and saved that process. What are the benefits of the motion for direction? Well, for defense lawyers, aside from the efficiency and not having to go through a 2-stage hearing, are that the complainant doesn't get to participate in the process. And as I'm about to talk about, that there are actually ways that you can shield some of that evidence from the Crown attorney and give it just to the judge. And separately, by not having to go through the 2-stage process, you don't have to reveal how you're going to use it. So there are good reasons to do it. I should say as well, one of the challenges that I'm finding a lot is that there are so few cases out there on this issue. And so I say sort of the responsibility falls on all of you, that there's a provision in the 278 and 276 regime that allows judges to make public these judgments, but a judge has to rule on that. So in the absence of a judge's ruling, you're not going to be able to use that. It's not going to get published. You're not going to be able to share it with others. So ask your judge, if you get a good ruling, will you also, sort of under 278.95, I think it is, will you sort of rule that this can be used in other cases? The cases where I've done that have been helpful, and I've relied on those same cases over and over again. The Crowns aren't doing this, so we can build up a body of case law that can be really helpful. Sorry, I should just go back there for a second. The idea about motions for direction, do them in camera. This is a strategic decision. 278 applications and 276 applications are supposed to be done in camera. The last thing you want is to screen all this stuff before that happens and the complainant is able to get a copy of the recording or can sit in the courtroom and listen to what's being said. So by asking for it in camera, not only are you sort of adhering with the spirit of the legislation, but it's also a way to sort of shield the complainant from learning about what you're up to and prevents the Crown attorney from disclosing it to the complainant. Complainant participation, JJ left open the possibility of complainant participation, but there are many cases out there that really question why a complainant would need to participate at a motion for directions hearing, especially when they don't get to participate at a stage 1 hearing. I've given you those cases. Also, don't let the Crown attorney force you to combine a motion for directions with a stage 1. The whole purpose of it is that you don't want to reveal your strategy, where you're going, what you have. And the last thing I'll say is just about filing things under seal with the judge. There is good authority to do this. I've given you some cases, CT, AJ, AM, and there's another case called Flammenbaum, where the judges all accepted materials under seal. The Crown only got a judicial summary the way a Step 6 Garofoli application would work. And keeping them in the dark to the extent that you can is a strategic consideration, but it's also something I think could really benefit you. And now off to Meaghan again to talk a little bit about private records.
Okay, I'm back. So in terms of private records in our possession, the code sets out what we're doing, right? So the enumerated records, that's obvious. If you have something that falls in one of these categories, you have to go through 278. If you are dealing with a non-enumerated record, your trial judge is going to have to determine whether the material is highly private. That's the wording we're getting from JJ, and whether the complainant has a subjective expectation of privacy in the record that's objectively reasonable in the circumstances. And there are many reported decisions on this. It's a very fact-specific determination. We don't have categories of things that are always going to be 278 or always not going to be 278 once you're outside of the enumerated record category. It's very fact-specific. specific. I mean, there's cases that go both ways. For example, on family court applications, there's going to be cases where you might have a mix of records that contain private information and not private information. So you might be able to redact out the private information and be able to rely on the information regarding the complainant that would be considered not highly private. So these are all things you're going to have to consider when your client hands over materials to you and you're looking at, does this fall within what's considered a record under 278.1? Once you've either done your motion for directions because you know that, and you've gotten your answer that you have to go through 278, or you just know, as Dan said, I don't need a motion for directions, I know I'm dealing with 278, you're into a two-stage process. So I provided an overview of the two stages that anyone who's gone through an application like this will be familiar with. So I won't spend any time on that. I would highlight, though, that on the point of there's not a lot of reported cases, I have provided an example of a stage 1 decision that's reported from earlier this year by Justice Whitkin, who we know is one of the co-authors with Dan on their book, which is a fantastic resource. I can't recommend it highly enough. I've also provided an example of what happens if you're dealing with a record as defined by 278.1, but you're also tying in a 276 application. So I provided an example, a Court of Appeal decision from earlier this year that, again, kind of talks about how you're going to deal with that, and Dominic will go through all the 276 stuff with us. Also, just to be aware of, the Crown is subject to 278, right? We know this. I provided the citation for a decision from Justice Presser. So that's, again, just something to be aware of. This isn't something that you and the Crown can just work out on agreement unless the complainant waives the operation of the section. Just because the Crown has it, they can't simply disclose that to you. You guys can't come up with an agreement to use it without going through 278 unless the complainant has expressly waived the operation of those sections. So the part of 278 that I really wanted to touch on with everyone today is how do you use the material once you have it? So there's the obvious things, like if you want to enter it as a record, if you want to be able to, as an exhibit at trial, if you want to be able to cross-examine the complainant on it, you're going to have to go through 278. There's many cases, not just JJ, but trial decisions since JJ that go through just referencing something that's contained in a record to use it for the purpose of cross-examination. That is using the record, that is adducing the record. The term adduce in the code, there's a broad interpretation to it. So whether you're planning to use it in the examination or cross-examination of a witness, you don't have to be tendering it as an exhibit. You still have to go through 278. If you have obtained a record through another process, for example, a third-party records application, once you have that record in your possession and you think, this now might also qualify as a record that is, in relation to the complainant, highly private, contains information that's either enumerated or whether it's non-enumerated, you think it still falls in the category, you have to go through 278. So that, there is no way around this. The next section I have, or example I have there, is to use a photo or a video. And so Dan touched on this a little bit, but if you have a record or material that's explicitly sexual, you have to go through 278. So one of the examples that I've provided there is a decision by Justice Brock Jones, and that was where the records at issue where there were 4 friends who had taken photos when they were hanging out in a hot tub. So people are in bathing suits, and the question was, are these explicitly sexual? Do these qualify as records? And so Justice Jones found that the photos were not created in a private setting. It was a social gathering. There was no evidence of a relationship of trust or authority between the parties, and allowing their introduction would not reveal highly sensitive information about the complainant. So these are really fact-specific analyses, and you're going to have to figure out what the relevance is, how you're going to tie this to your trial strategy to be able to make these arguments, even when it's something that should seem as obvious as, is this a record of an explicit sexual nature, which is when JJ tells us the complainant, the dignity of the complainant might be engaged, and it might be a 278 record. There's still room for the arguments to be made, but you have to do the research. You have to come up with these ideas and put them through to your trial judge and see if it sticks. The last point I wanted to make on 278 is the independent knowledge ground. So JJ tells us that if the defense has independent knowledge of information that's gathered from sources that do not rely on a complainant's private records, defense counsel can use that information without invoking the record screening regime. How do you do that? It's very much an unresolved question with respect to the burden, the standard of proof, how are you supposed to navigate issues of solicitor-client privilege? So what I would point you to is first principles. You are going to need to demonstrate that you have a good faith basis for the suggestion, the question that you want to be able to put to the complainant. I've provided an example where defense counsel, it's a decision from the Quebec Court of Justice, made the pitch about asking the complainant questions about her health and specific medications she was on, and the argument was unsuccessful. So it's a very sticky, tricky area. I don't have any great words of wisdom on this. I don't know if Dan does. It's a tricky thing. I don't think there's really any decisions that are helpful on it yet. I simply flag this as, JJ tells us this is the thing we can do. I don't know how you do it, but it's there. So I'll pass that over to Dominic now.
Thanks, Meaghan. Is that the right one?
Yep.
Oh, thank you. Okay, very briefly, 276. Last time I was here, a couple of years ago, we were trying to sort out the mess that was JJ. It had just come out, and I was talking to somebody earlier today about Reimer, and even that case is, as it seems all these 276, 278 cases are, it's a tough read. And I keep thinking about that statement of future intent basis for the admission of the evidence, and I'm thinking, I'm sure I've tried that before. Dan, have you ever argued that before yourself?
Oh, yeah, I was like laughed out the room.
Yeah.
Like, how could that possibly be a relevant use of these text messages? So it may not last long, so argue as many as you can for now.
Anyway, it's great. It's so for this, just let me jump on. I'm just going to get 4 takeaways from the recent case law. From Reimer, Justice Pacheco, Dan mentioned this idea of pushing the 276 application stages together. It's a 2-stage process, and I think don't be bullied into doing that by trial judges or by Crown attorneys. Do your stage 1 separate, I think, is to your client's advantage in every case. I think from Reimer in particular, I wrote an expansive interpretation of the wording in terms of subject matter of the charge. I think it's very generous. I think it's a somewhat expansive based on what we've been dealing with for the last few years. 3, construction of affidavits is of the utmost importance, and it's going to depend on the type of case you're dealing with. Is it a consent case? Is it a case where it's a denial case? How you're working, whether you're putting those affidavits in at all, whether it's a BDSM case. And finally, this sort of a clarification or restatement, really, of the DARA principles on 276. It prohibits inferences from the sexual nature of the activity, as opposed to inferences from other potentially relevant features of the activity. That's the thing that I keep, my head keeps spinning on, but I think it's very valuable. Subject matter of the charge. Let me just take you through very briefly the test in Reimer that comes up. Justice Pacheco had said, there are cases where proximate sexual activity that is not the immediate subject of a prosecution will be sexual activity that forms the subject matter of the charge, and that's great. And it's exempt from 276. So it opens the door a little bit, I think, for us. I think the problem is how he lays out that test. It's not hugely permissive, but I think it's up to all of us to push it as far as we can. And ultimately that test is it must be so integrally connected, intertwined, or directly linked to that activity, the actus reus of the specific charge, that it's effectively part of the transaction or event. I would have, if I were editing that decision, I would have taken the "so" out of it must be integrally connected. I don't think we needed the "so," but it's still a tight test, but I think this opens the door a crack for us to get all of that important sort of information that flows in and around the charges in via 276 without a 276 application. Two other cases I've put in there that are important for you. One of them's not particularly new, Lennox, where those are examples where that and Chudari, the 2023 Court of Appeal case, where you see the sort of how far you can move. They're good examples for you, hopefully, in terms of how far you can go in terms of not invoking the 276 regime. The other aspect I wanted to talk about briefly is affidavits. Obviously, look, they're always going to be difficult. I think the first question you got to ask is whether you're going to put an affidavit in. Secondly, how much detail are you going to include in that affidavit? You're going to have to put enough in there to establish a basis for admissibility, and you're going to have to figure out an approach, and of course that very unhelpfully in this slide says on a case-by-case considerations. But in the PowerPoint presentation, I think HP obviously gives you a lot of guidance in terms of what can happen to your client if there's just too much detail in those affidavits. There were two affidavits in HP. One of them outlined his account of the sexual assault and all of the interactions that occurred on the evening in question. The second described the prior sexual relationship, timing and nature of encounters in particular. There was a very lengthy cross-examination in the 276 voir dire, and ultimately it really did not accrue to the benefit of the accused in that case, and was ultimately led to the rejection of the accused evidence. We know that's what we're up against if these affidavits go in. I think HP is a very valuable case to read. The other area I wanted to address is the scope of Crown cross-examination on affidavits, and there's a lot of value in HP as well. And I think that's where you have to really sort of get yourself into a situation where you sketch out what you can object to in advance, get it on a piece of paper and be ready. Dan, comments from you in terms of objections?
Yeah, just put in the bare minimum you need to make the point you need to make, and if the Crown steps over the line anywhere, you object, and take them to HP. It's the Court of Appeal was really clear that they shouldn't be able to go beyond the four corners of your affidavit. If you open that door, they can walk right through it.
Last slide I'll address in this presentation due to is deficient affidavits. I've given you RVTWW, something to read in terms of deficiency of affidavits. A lot of this is going to come down to how important the evidence is to you. I've had situations in our office, I was telling these guys about it recently, where we had a 276 issue involving Backpage. It was a human trafficking case. And we made a conscious strategic decision not to put an affidavit in from the accused. We used a clerk affidavit. And the judge ruled against us, but we thought we might be able to win it without the accused putting in the affidavit to connect it to the case-specific relevant issues. We were unsuccessful, but what we had done beforehand is we had really ranked, we had sat down and done a sort of strategic run-through of our cross-examination areas, and it really ranked in the bottom third. And when we did the assessment, we said, look, there were some issues with the accused being on the stand, so we just didn't put that in. And that's what can happen, though, with deficient affidavits, and you're going to have to do a cost-benefit on that. And that's all I'm going to go through. Just remember, narrative and context are not enough for those affidavits, and you'll find all of that in my presentation.
Thanks very much, guys.
Thank you.
Thank you very much to our panelists.